The law on the point of summoning additional accused in exercise of power conferred by Section 319 CRPC is well settled. One may profitably refer to and rely on the Constitution Bench decision of this court in Hardeep Singh v. State of Punjab 2014 3 SCC 92, where law has been authoritatively declared. We consider it proper to quote the conclusions reached by this court qua the questions arising for decision hereunder. We accordingly sum up our conclusions as follows. What is the stage at which power under Section 319 CRPC can be exercised? And whether the word evidence used in Section 319(1) CRPC has been used in a comprehensive sense and includes the evidence collected during investigation, or the word evidence is limited to the evidence recorded during trial? In Dharampal Case 2014 3 SCC 306, the Constitution Bench has already held that after committal, cognizance of an offence can be taken against a person not named as an accused but against whom materials are available from the papers filed by the police after completion of the investigation. Such cognizance can be taken under Section 193 CRPC, and the Sessions Judge need not wait till evidence under Section 319 CRPC becomes available for summoning an additional accused. Section 319 CRPC, significantly, uses two expressions that have to be taken note of: one, inquiry to trial. As a trial commences after framing of charge, an inquiry can only be understood to be a pre-trial inquiry. Inquiries under Sections 200, 201, 202 CRPC, and under Section 398 CRPC are species of the inquiry contemplated by Section 319 CRPC. Materials coming before the court in course of such inquiries can be used for corroboration of the evidence recorded in the court after the trial commences for the exercise of power under Section 319 CRPC, and also to add an accused whose name has been shown in column 2 of the charge sheet. In view of the above position, the word evidence in Section 319 CRPC has to be broadly understood, and not literally as evidence brought during a trial. Whether the word evidence used in Section 319(1) CRPC could only mean evidence tested by cross-examination, or the court can exercise the power under the said provision even on the basis of the statement made in the examination-in-chief of the witness concerned? Considering the fact that under Section 319 CRPC a person against whom material is disclosed is only summoned to face the trial, and in such an event under Section 319(4) CRPC the proceeding against such person is to commence from the stage of taking of cognizance, the court need not wait for the evidence against the accused proposed to be summoned to be tested by cross-examination. What is the nature of the satisfaction required to invoke the power under Section 319 CRPC to arraign an accused? Whether the power under Section 319(1) CRPC can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted? Though under Section 319(4) CRPC the accused subsequently impleaded is to be treated as if he had been an accused when the court initially took cognizance of the offence, the degree of satisfaction that will be required for summoning a person under Section 319 CRPC would be the same as for framing a charge. In paragraph 106, the court held thus, "We hold that though only a prima facie case is to be established from the evidence led before the court, not necessarily tested on the anvil of cross-examination, it requires much stronger evidence than mere probability of his complicity. The test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. In the absence of such satisfaction, the court should refrain from exercising power under Section 319 CRPC. The difference in the degree of satisfaction for summoning the original accused and a subsequent accused is on account of the fact that the trial may have already commenced against the original accused, and it is in the course of such trial that materials are disclosed against the newly summoned accused. Fresh summoning of an accused will result in delay of the trial. Therefore, the degree of satisfaction for summoning the accused, original and subsequent, has to be different. Does the power under Section 319 CRPC extend to persons not named in the FIR or named in the FIR but not charge-sheeted or who have been discharged? A person not named in the FIR, or a person though named in the FIR but has not been charge-sheeted, or a person who has been discharged can be summoned under Section 319 CRPC, provided from the evidence it appears that such person can be tried along with the accused already facing trial. However, insofar as an accused who has been discharged is concerned, the requirement of Sections 300 and 398 CRPC has to be complied with before he can be summoned afresh. Quite recently, a coordinate bench of this court in Jitendra Nath Mishra v. State of Uttar Pradesh, 2023-7 SCC 344, upon considering Hardeep Singh case, had the occasion to observe as follows. Section 319 CRPC, which envisages a discretionary power, empowers the court holding a trial to proceed against any person not shown or mentioned as an accused if it appears from the evidence that such person has committed a crime for which he ought to be tried together with the accused who is facing trial. Such power can be exercised by the court qua a person who is not named in the FIR, or named in the FIR but not shown as an accused in the charge sheet. Therefore, what is essential for exercise of the power under Section 319 CRPC is that the evidence on record must show the involvement of a person in the commission of a crime, and that the said person, who has not been arraigned as an accused, should face trial together with the accused already arraigned. However, the court holding a trial, if it intends to exercise power conferred by Section 319 CRPC, must not act mechanically merely on the ground that some evidence has come on record implicating the person sought to be summoned. Its satisfaction preceding the order thereunder must be more than prima facie as formed at the stage of a charge being framed, and short of satisfaction to an extent that the evidence, if unrebutted, would lead to conviction. It is in the light of such settled law that we need to examine the impugned order of the High Court. However, we must exercise caution lest any observation has the effect of influencing the trial.